All right, good morning, everybody. My name is Tracy Decker, and I want to welcome everybody to today's seminar. I'm a member of the State Bar of South Dakota, and I'm also currently the Assistant Chief Deputy State's Attorney for Pennington County, and I'm the President of the Public Sector section of the State Bar. So before we get started, I have a few housekeeping things I need to let you know about. And the first is to let you know about resources available to lawyers who may be struggling. Do you or a lawyer or law student you know have a drug or alcohol problem or are struggling with depression or anxiety? Lawyers Concerned for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with Lawyers Concerned for Lawyers is strictly confidential and privileged. You can call Becky Porter for more information at 605-391-5191. Becky is a Lawyers Concerned for Lawyers member, and your communications with her are likewise confidential and privileged. South Dakota bar members and their families also have access to the Sand Creek Member Assistance Program, which includes a 24/7 hotline. To reach a trained professional at any hour for confidential discussion and assessment, call Sand Creek at 1-888-243-5744. These numbers will also be added to today's chat feature so that you can copy them down at your convenience. Today's presentation, we will be available for approximately 1 hour. I don't know how much of that will be the speaker speaking and how much will be question and answers. So please submit questions if you have them. You can submit questions to today's presenter by typing them into the chat feature, and you can send questions in at any time during the presentation. We can collect these and present them at the end of the session unless Jack sees any that he wants to answer right away. And next, I'd just like to thank the State Bar and CLE Incorporated for their support of today's program. And specifically, I want to thank the South Dakota Public Assurance Alliance. They are sponsoring our speaker's time today. So I'd like to thank them for helping us ensure that we have a quality speaker to discuss these important issues today. So thank you to the South Dakota Public Assurance Alliance. And now I'm going to introduce our speaker and his partner, who is also there with him. Jack Heeb was born and raised in South Dakota and attended Augustana College in Sioux Falls, where he obtained a Bachelor of Arts degree in Government and International Affairs. Following that, he went to the University of South Dakota School of Law in Vermilion. And prior to joining the Richardson Law Firm, he practiced with Lee Schoenbeck in Webster, South Dakota, and also has served as Dade County State's Attorney. He has been a partner at Richardson Law Firm since the year 2000. And he's joined by his partner, Zach Peterson, who has served as law clerk to the Honorable Charles B. Kornman, federal judge for the District of South Dakota, and he has been a partner at the Richardson Law Firm since 2009. And with those introductions, I would like to present Jack Heeb for today's presentation.
Thank you, Tracy. As Tracy mentioned, if you have questions, go ahead and throw them into the chat feature. I've actually figured out how to pull that up. So hopefully you've all gotten access to this checklist that we put together. I know Tracy sent out an email. I think she said it's available on the website. What we were trying to do with that checklist is just give you something that you could take away from this and, save it electronically or otherwise, as a means of kind of going through the laundry list of things that we've encountered in these cases, most of which we've actually litigated, or some of which have been the product of legislation in the last 4 or 5 years on these subjects. I will tell you that the focus of the presentation is really going to be on conditional use permits. That's where we spend the vast majority of our time, and that's where we see most of these appeals popping up. We could certainly try to help answer questions with respect to other types of appeals, whether they relate to variances or other zoning issues. But this is sort of set up to deal with conditional use permits because that's where we see the majority of the work in this area. So I'm just going to launch right into using this checklist to kind of go through the topics one at a time. And if somebody does have a question on a topic that I'm talking about, throw it up on the chat. I may not wait till the end. We may try to address it as we're dealing with that particular issue. Where it starts is if you're involved in this, whether you're representing someone who wants to make an appeal, or whether you're talking and representing somebody who is having a decision challenged, is with a petition. Quite frequently as lawyers, we deal with complaints and summons, and this is a different process. This is an appeal. And I think sometimes people lose track of that when they are involved in these things. There's no need to serve a summons. There's no need to take the traditional steps that you would need to take. But the first step in the process is, is the petition timely? And what's interesting about that is the statutes that we've cited there talk about that it has to be filed within 30 days of the decision. This is a little murky in this world. And depending on who you're dealing with and who you're representing, you're not talking about a clerk of court's office. You're talking about a zoning board or a commission. And when they, quote, file their decision, can kind of be up in the air a little bit. So that's the first question that you need to ask, whether you're representing someone who wants to challenge or whether you're representing a body, is what's my deadline here for filing this? And what the law says is 30 days after the filing of the decision. I think we've actually litigated this once, haven't we, Zach, on when was it filed?
I think the issue was there was an amendment to file decision. And so the question was whether the amendment extended the deadline or not.
Right. So, really what we've looked at from a filing standpoint, and I think what the court has sort of adopted, is this idea of, well, when does it show up in either the secretary or the auditor's file? I mean, what is the date of the decision that's being appealed from? But that's the first step in the process, is to look at, is it timely and how long do I have to get this done? My suggestion would be sooner rather than later if you're on the filing end of it, but it's also something you want to look at if you're defending it. The second question, this one's pretty simple, but it's often overlooked. Is it verified? A petition for this form of relief, unlike a complaint where the attorney can just sign it for the client, it has to be verified, which basically means it takes the form of an affidavit, that they're verifying the truth of the content of the petition. Fairly simple requirement, but one you don't want to miss if you're the one filing it. And it's also one you don't want to overlook if you're the one defending it. The third one, and this one gets into the meat of this a little bit more, and this is where we see the majority of what we would consider to be the mistakes made in this world. Does the petition pursue the correct relief? And when you're talking about conditional use permits and you're talking about challenging those, there is a very, very narrow standard of review. Because remember, we're talking about an appeal here. We're not talking about an original action. We're talking about an appeal. And what the statutes now say is these are reviewed under a writ of certiorari standard. And that's what you have to file, is a petition for writ of certiorari. And so we've seen all kinds of attempts to get around that, because if you look at what is a writ of cert standard, it's a very narrow standard. And we'll talk about that a little bit more later, but we've seen people use all different kinds of vehicles to try to basically get around that obligation to file this as a petition for a writ of certiorari. And the reason that they're doing that most of the time is they're trying to get a broader standard. They're trying to get a standard for relief that is not available under a writ of cert standard. And so when you look at the face of that petition, if you're the one defending it, or if you're the one preparing it, you need to make sure that you allege the proper allegations seeking the proper relief. If you don't, you're going to be subject to a facial challenge, right out of the chute. If you don't come in and allege that, look, I'm entitled to a writ of cert here, and I'm entitled to relief under a writ of cert standard. Well, let's move on then to the next category. What is it? What can the court look at legally? What the court can look at is really the legality of the decision. Did the board exceed their authority? I mean, those are the buzzwords basically that we deal with. And what does that mean? Well, what that means is, did they do more than what the law allowed them to do? And the mistake we see people make quite frequently is they think, if we don't agree with the board's decision, if we think the board got it wrong, they took evidence from both sides. In some cases, maybe they only took evidence from one side, and they made a decision that we think is inconsistent with the evidence they took. Well, we're going to appeal, and we're going to ask the court to overturn that decision. The problem they run into is this writ of cert standard. The court under the law is not allowed to look at the correctness of the decision. All they're allowed to look at is, did they act legally? Did they exercise their discretion within the bounds of what the law allows them to do? And if you look at this category 4A on the checklist, where we talk about grounds for a facial standing challenge, this is something that we've dealt with, where we say, look, these people either don't have standing, and we're going to get to what it takes to have standing now, because they haven't alleged anything on the face of their petition that would suggest they have standing, or they haven't even alleged that the board did anything that exceeded its authority. All they're complaining about is the efficacy of the board's decision, and that's not enough. So you're going to end up with a facial challenge if you don't pay careful attention to what is the standard of review, and do we have standing? Do the people I'm representing have standing to bring this? The standing issue used to be a lot simpler, because the statute used to give taxpayer standing to anybody who wanted to challenge a conditional use permit. So all you had to do was find somebody who was paying taxes in the jurisdiction, and you had standing. That's now changed. The legislature has changed that. And what they've adopted, if you look at the notes behind 4A on the checklist, is really what we often refer to as the cable standard for standing. And that they've statutorily adopted the factors that the Supreme Court laid out in cable for the most part. I'm getting that right, aren't I, Zach?
Pretty close.
Okay. Zach's the brains of this operation. You'll all figure that out sooner rather than later, probably. But the cable standard requires that you show that your client, or that the petitioner show, that there's something that affects them differently than the general public. I mean, that's the 50,000 foot view of the cable standard. And quite frequently, people will say, well, I live really close to where this permitted use is going to be, so that makes me different than the general public. That's really not enough. You need to allege specific facts that will pull you out of the general public category and move you into the category of someone who would really have standing to challenge the decision that was made by the board. You look at 4A and 4B, we cite some cases there, some fairly recent authority. The Turner County case, Powers versus Turner County, which came down in 2020, does a really good job of describing the kind of evidence necessary for someone who wants to file one of these petitions to show that aggrieved status that's required now under the law. I mean, I would highlight that if you're thinking about filing one of these petitions. I would read that case and look at what the court says there about standing. before you put together that petition, because it's going to really enlighten you as to what you need. And in some cases, I'll tell you, you may need to go find a different client, which isn't necessarily hard to do. You know, when you're representing people with these types of things, they often come to you as a group. You know, they'll come to you, there'll be 5 people that are all neighbors and they've banded together. There's 40 of them. And as an attorney, if you're going to file one of these petitions, you need to look at the standing requirement, look at your group and say, okay, is there one or more of these people? Or maybe we need to create an organization or a group so that we can properly allege standing and we can get past go essentially on the petition. I must be doing really well because nobody's asked any questions yet on the chat. So we'll just keep rolling through this. Let's move to the merits. And I talked about this a little bit ago. You need to allege in your petition that there was either a lack of jurisdiction or illegality, that the board exceeded its legal authority in that petition. Those are really the 2 routes that you can go with in order to have a potentially successful petition. What we've seen a lot of, and this has now been sort of ferreted out, I think the Supreme Court has pretty well cinched this one up. We used to see a lot of what I would call technical arguments. People would say, well, the board's ordinance required that they publish notice of the meeting on both their website and on a bulletin board, or, you know, make up whatever you want to make up. And then you would have a bunch of people show up at the hearing, most of the time the same people who were then later filing a petition, and one of their allegations would be there wasn't proper notice given. Well, you know, and we deal with this later in the checklist more specifically, but that's a technicality. And if you showed up and you argued about it, well, you've waived notice. Or I don't know, you have any other examples, Zach, of technical things that have been raised that the court has said, you know, this isn't really what this is for?
You know, I was thinking specifically of, you know, with the findings that the board ultimately renders, complaining that they aren't specific enough or detailed enough or things like that. You know, basically challenging the form of the board's decision instead of the substance, and those really haven't been successful.
Yeah, that's actually a good one. And that's the other thing, as long as he brought that up, if you're representing the board, if you're the one that is shepherding them, you know, through this process, you need to make sure that you look at 2 things. Number one, the ordinance that you're operating under, which I will tell you quite frequently is not consistent with the law, because people haven't gone and bothered to amend their ordinances to catch up to the law. So they'll have something in their ordinance that says, you know, if you disagree with the decision of the board, you must file an appeal with the county commission, you know, within 30 days or something. And the statute might now say, well, no, the appeal is directly to the circuit court via writ of cert. And so you need to look at both. And I will tell you, if you represent organizations, the best thing you can do for them is to go pull out their ordinances and look at the statutes and make sure that they're consistent. And if they're not, get them cleaned up, because then you're going to avoid one problem right out of the chute by having an ordinance that, you know, causes people to do things the wrong way when they're trying to appeal it. And then the various arguments that you're going to get about whether, you know, the ordinance controls or what should be done about that. We see that quite frequently. The law generally requires, in many places, that the board issue a decision or make findings. Once again, we've seen technical arguments about, well, they made the findings before they even had the hearing, or there were proposed findings prepared ahead of time. And that means that the board didn't really consider the evidence. They had their mind made up. Well, that's not true. I mean, they didn't have to vote that way. Many times it might be the auditor or the person who's in charge of the board that prepares them ahead of time with the idea that, well, if this goes through, we'll have them. There's no requirement that those things be done contemporaneous with the decision. And my recommendation, or our recommendation, is, look, you can have the board issue its decision, and then you can create findings based upon what happened at the hearing that are consistent with that, have the board approve those, even at a subsequent hearing, and then the appeal can go forward. But you need to cross those T's and dot those I's. The other thing that we have come up frequently, and this is a question that gets asked of us, is, well, do we need to record this? Does it need to be recorded? Our answer simply is no. The law doesn't require you to record it. If you're going to record it, if you're going to keep a contemporaneous record, a word for word record, hire a court reporter, have a court reporter come in and do it. Because when these people set a iPhone in the middle of the table and try to record it, at some point, somebody's going to have to go type that up. And it really irritates me when it's us, because you can't tell who's talking. A lot of times you can't hear everything, and you're creating almost a bad record, not a good record. But the law doesn't require that it be recorded. The law requires there be findings. And, quite frequently that question gets asked, and we tell them, well, it doesn't have to be done. The next question is, well, who can do it? If you're representing a group of people and there's going to be a hearing on a conditional use permit, you can bring your own court reporter. My advice would be, work with the board ahead of time. Tell them, we plan on bringing somebody. We want to make sure you know that. We'd like a record of this, but you can create your own record at these hearings if you think that's going to be beneficial, or if you think that's something that should be done. But there's no legal requirement that there be some sort of a contemporaneous recording of the meeting. We'll move forward a little bit now and back to this checklist that we're going through, talking about the merits. And we already talked about jurisdiction, illegality. We talked about notice. If you can't complain about a lack of notice if you showed up at the hearing and argued about it. So what we found is that's been waived now if you actually show up and argue about it. The next thing on the list is the ordinance that you're operating under, was it validly enacted? Now this one's interesting. And we had a run of these a few years ago where the tactic that got used, and you need to think about zoning, the big picture on zoning, to really understand this and understand why I think this isn't necessarily a good argument. But we had a run of these where the people challenging the decision of the board were going back and looking at the ordinance that the board was operating under, and they were trying to see whether that ordinance was validly enacted. The idea being, if the ordinance wasn't validly enacted, well, then the board didn't act legally by acting under it. Okay, good argument, except that if you kick the ordinance out, what are you left with? In some cases, you're left with nothing. All right, so that's what I'm talking about with the big picture here. You don't have to have zoning. Zoning is optional. Zoning is a it's a restriction on a landowner's right to use their land as they see fit. And it's not required. And there are still counties in the state that have no zoning, and that's perfectly acceptable. I mean, we've evolved into this society where everybody thinks that everything is regulated. It doesn't have to be. So if we back up now and we talk about, hypothetically, I'm representing a group of people that are irritated about some decision that a board of adjustment made on a conditional use permit. And I say, okay, I'm going to go see if the zoning ordinance was validly enacted. Well, that's great, except you better look and see what you're falling back to if it wasn't. Because remember, the people challenging these for the most part are people that are angry about the fact that the board has not restricted a landowner in the way that they wanted them to be restricted. Let's use pig farm. You know, my neighbor wants to put up a pig farm. My neighbor is required to get a conditional use permit to put up the pig farm. I go to the board meeting. I argue that they shouldn't be given a permit for their pig farm. The board says, nope, we're going to give it to them. Well, if I'm going to go challenge whether the ordinance that caused that hearing to have to take place in the first place is valid, I better make sure that there's a prior ordinance that would have been more restrictive than the one they're operating under, because if I'm successful now with that challenge and saying, oh, that ordinance is no good, I may be left with no zoning. I may be left with the situation where the person who wants to build the pig barn doesn't need a permit of any kind because there's no zoning now. I've gotten the ordinance kicked out. So but that is something that has been used, and it's something that you need to look at. If you represent an entity that has a zoning ordinance, it's actually worthwhile to go and make sure they pass the thing the right way. Make sure that they had, you know, the two readings and the things that the law requires them to do legislatively to pass that ordinance. And if they didn't, clean it up. If you're representing somebody who wants to challenge an ordinance, take a look at it, or challenge a decision, take a look and see whether that ordinance that they're operating under was even validly enacted. But make sure you look at what you're going to fall back to if you're going to take that route, because you may be putting your clients in an even worse position than they're already in if you're successful in doing that. I had a question about what about attendees making their own recordings at the hearing? Just random people that aren't your client. Really, anybody at a hearing, it really falls into one of two categories. They either fall in, I suppose maybe three categories. They either fall into a board member, or they fall into an attendee, or they may be an attorney representing an attendee, I guess, but you're still just an attendee at that point. I really think anybody who's got an interest in the hearing, yeah, I mean, they should have a right to record the hearing. I don't think there's anything in the law that prohibits it. It's not like a court proceeding where you're not allowed to record in the courtroom without the permission of the court. I will say this, if you're going to do it surreptitiously, there are probably going to be questions about the accuracy of the recording. So my suggestion would be, if you want to record it and you want to be able to use that recording as part of an appeal, you should probably make people aware of the fact that you're recording it. And as I said before, do it in a way that is going to make it usable. Zach's got something he wants to jump in here on.
Yeah, I'm actually handling one right now where a petitioner video recorded a Board of Adjustment hearing, and the circuit court admitted it into evidence under, in our case, it's a county appeal. So 11-264 allows for the presentation of evidence if the district or the circuit court wants to hear it. So it's something that's happening more and more. And we've got certain folks that record every hearing they attend. So it's something to be aware of. If you're the county, I think it's more on the side of the board members recognizing that what they're doing in this public forum could eventually be in front of the circuit court judge. So, be mindful of the things they're saying and doing.
Which in some ways brings us to our next topic on the checklist, which is the conflict of interest. This is something we saw a lot of for a period of time, a lot of it. That was kind of the challenge du jour for a couple of years, where if a board made a decision that people were unhappy with, they would immediately start digging into two categories: conflict of interest and ex parte communications. And I do want to touch on this before I dive into that. If you are representing boards, and I've given this speech before, they need to understand that they wear different hats when they're doing different things. And this is really sort of unfair to board members because they're not judges, they're not law trained, and they're not expected to necessarily know these things, which is why if you represent the board, it's really a good thing to talk to them about. They have legislative functions. And frankly, most of what they do as a county commissioner is legislative. They're being asked to make public policy decisions and amend ordinances or make decisions that affect the taxpayers of the county. And as with any legislator, you've got the right to talk to your constituents. In fact, if you don't talk to your constituents, you're probably not doing a very good job. Where that changes is when you're wearing this quasi-judicial hat, when you're the judge and there's a application for a conditional use permit that's been filed and there's been a hearing set. Now you're going to come to that hearing and you're acting in a quasi-judicial fashion. You're now a judge. And, judges know, circuit judges know that, look, I can't be talking to the litigants ahead of time in an ex parte fashion because if I do, I've got a problem and whatever decision I make is likely going to get overturned. That's now been tempered somewhat. And we've cited some law for you here that talks about that. It's under number 10 on the ex parte communications. But what we were seeing was a board would make a decision. They would grant the person the permit for the pig farm. And then immediately the people challenging it would want to dive in and start looking at, well, did any of the board members who voted on this, did they talk to the person who wanted the pig farm about it ahead of time? And if they did, well, then they had ex parte communications and there was maybe a conflict of interest. Or did one of the board members, does he or she self-feed? And were they going to benefit from the pig farm because now they were going to be able to sell feed to this person? And that was a conflict of interest. A lot of this really popped up. And for those of you who are zoning geeks, the Hainig case out of Winter, which had some pretty, interesting facts if you're familiar with that case. But what spun out of Hainig versus City of Winter was some legislation. And we've laid it out here for you on the checklist. And the real upshot of it was, look, if there is a conflict of interest, the only remedy is to kick out the vote of the person who had the conflict. It's not to go back and have a new hearing. So you need to be cognizant of that. And if you represent these boards, our advice has been, look, talk to the board ahead of time if you've got one of these contentious hearings coming. If you have a potential conflict of interest or an issue, deal with it ahead of time. Most of the ordinances that you operate under are going to have a process by which you can replace a board member. But understand something, if you don't replace them and this conflict comes up, and then the board member at the hearing says, well, I think I have a conflict, I'm going to recuse myself, you're really harming the petitioner at that point. Why? Because the only remedy is to kick out their vote. And so most of the time, there's a requirement that the petitioner get a certain number of votes from, the board. And you're basically creating a no vote in that situation. So go ahead.
There's a question.
Okay. The question is, have you ever seen issues with conversations between board and staff as conflicts or ex parte? The answer to that is yes, we have. Great question. I'm going to let Zach take it. We've had allegations made that it's somehow improper for the board to be taking information from planning officers or people that are responsible for collecting information on a application and then disseminating that to the board in advance. And we've had allegations made, well, that's improper. That's ex parte contact. And it's not. It's not. I mean, if it's a staff person, and in a lot of the bigger counties, you see this, where you have a planning commission, you have an entire staff of people whose job it is to pull together the things that are relevant to the application, and then to put them in a form that the board members can, get through and look at when they're being asked to have this hearing and make these decisions. And we've had that issue come up, and the court has never said that that type of contact was improper.
Yeah, and typically the ordinance will indicate that the zoning officer has an investigative function with respect to these things. At least some of the ones that we've analyzed have had those type of provisions. So I mean, they're really duty bound to go out and collect information and present it to the board members.
Yeah, but yeah, so I mean, the bottom line is that has not been deemed an issue or an ex parte contact that's improper. And what I would tell you to do, if you're looking at this conflict of interest question, the case that just came down and we were involved in it is that Holborn case, Holborn, and we cited here in the materials. And that case really, I mean, the Supreme Court, I think, has really sent a message when it comes to conflict of interest. And maybe Zach will disagree with this, but I think they've really sent a message saying, look, if we're not going to say this rises to a level of a due process violation unless you fall into a couple of really narrow categories. I mean, direct pecuniary interest by a board member, and that means direct. It doesn't mean that your second cousin twice removed is a potential partner in the pig barn. It means that you are a partner in the pig barn. You are going to derive a direct pecuniary benefit from the vote that you are engaging in, which goes back to Hoenig. If you know the facts of Hoenig, that was really the allegation there. But if you read Holborn, it really kind of sets the standard now. And I think it's going to be a lot harder to make those arguments successfully when it comes to conflict of interest, or frankly, ex parte communications, when you look at the statute that we've cited there with respect to that. Jumping forward now, and this goes back to what I talked about previously, but I'm gonna talk about it again because we continue to see it frequently. I mean, number 11, does the petitioner attempt to challenge the merits of the decision? And I just want to re-emphasize this for those of you who are thinking of taking on one of these cases for a group of people who have come to you and they've said, we just think this is wrong. We want to challenge it. I can't remember who gave me this advice back when I first started practicing law, but it's been good advice. As a lawyer, you're being paid to give advice, not to file suits. You're being paid, sometimes you're being paid to tell somebody what they maybe don't want to hear, but at the end of the day, they're going to be happy that you did it instead of taking a giant retainer from them and then basically beating your head against a wall that you're never going to break through. We see that so frequently here, and people will say, well, this is ridiculous. What's their remedy? If they can't go to the circuit court and they can't challenge the efficacy of the board's decision, if they can't ask the court to say that the board got it wrong, they have no remedy. And the answer to that is that's actually not true. They do have a remedy. The remedy is at the ballot box. The remedy is go elect different people. They may be the people that are directly involved in making the decision in a small county where you have county commissioners that also serve as the board of adjustment, but they may be the people that are appointing the people that you think are making bad decisions. Either way, the remedy is at the ballot box. The remedy is going and electing people. And I've had people come to me on that side of the fence and say, well, if we can't challenge the merits of this decision, what do we do? What do we do? And I tell them, put your effort into electing different people because they have a lot of discretion, And that's what that writ of cert standard is all about. You know, it's about saying, we're not going to let you challenge whether the board got it right. We're just going to let you challenge whether they acted legally and within their jurisdiction. And if you take a $50,000 retainer or a $100,000 retainer from a group of people that think, by God, we're going to fight this thing all the way through the Supreme Court, well, they probably will, but they're probably going to lose. And they're never really going to get to have their day in court like they thought they were going to have. And then they're going to be mad at you because they're going to say, well, why didn't you tell us that we really had no chance of winning this thing on the front end before we went to all this trouble of doing it? Finally, the last topic on our list is, does the petitioner's challenge relate to the board's interpretation of the ordinances it administers? Now, that's a lot of words, but what it simply means is, does it challenge the way the board is interpreting its own ordinance? And we've got some guidance on that now. We've got some law on that, which says it's basically the same standards you see at the federal level when you're trying to challenge a federal regulatory entity's interpretation of its own ordinances. There is deference given to the board. So the board is allowed to fill in the blanks in its ordinance as long as it fills them in a way that is not then inconsistent with the rest of the ordinance or with the law. You need to be cognizant of that. And, you know, if you're representing a board, you need to understand that you need to give them that advice. You have a right to interpret your own ordinance. You know, and this comes up. I mean, it comes up frequently. The one example, and I think it's a case that was reported in the Supreme Court, we had a situation where the ordinance did not allow a conditional use permit to be issued if it was within a certain distance of a well. Well, what happened was the word got out. These people were filing an application for a permit, whether it was going to be a cow barn or a pig barn. I'm sure it was one or the other, probably, wasn't it, Zach?
Yeah, it was a pig barn. Pig
barn, okay. And then the opponents went and drilled what they called a well within the setback, thinking, okay, we're going to drill a well and we're going to, you know, put a stop to this. Well, unfortunately, that's all they did. They dug a hole and they pumped some water out of it and said, we have a well. The board in that case said, that's not a well. A well is cased. It's, you know, certified with the state. And now none of that was in their ordinance, but they were allowed to define the term well because it wasn't defined in their ordinance in a way that was reasonable. And the court said, that's a reasonable interpretation of a well. We're going to give deference to that interpretation. And so that's just one example, but it comes up quite frequently, and you should be cognizant of that. That Chevron standard that you see at the federal level, we now have it at the state level as it relates to these types of ordinances. So I've gotten through the checklist. Tracy assured me that if I took less than an hour, nobody would complain. And we will take questions, though, if anybody has anything.
Jack, I do have a couple, I think, basic questions, because this isn't really my area of expertise, but sometimes I am tasked with helping. So
sure.
Just going back to the very beginning when you were talking about the amendment extending the deadline, I may have missed it. Does the amendment actually extend the deadline for when the petition needs to be filed?
I'll let Zach answer how it came out in that particular case.
That case came out of Sully County, and it's a reported decision with the South Dakota Supreme Court. They determined that the amendment did not extend the deadline because it wasn't a substantive amendment that changed anything about the permit.
Okay, so it could depend on what the amendment actually does.
It could.
Yeah, I think that's fair. I think it would have to be something substantive.
And then another question I had as this was coming through, you said some county ordinances have people appealing the Board of Adjustment to the Board of Commissioners, I think is how you said it, and that's not how it should be in statute. If a county ordinance has that, does that change the appeal process, or does it just take away rights from that possible appellant?
I will answer that this way. There was a time, because of the way the statutes were written, and this came out of a case down around Sioux Falls. I think was it in Turner County?
Are you talking about Ghost RV?
Yeah.
That was Minnehaha.
Minnehaha County, where that phenomenon existed. And it was because the statute talked about appeals from boards of adjustment. And because the Minnehaha County ordinance said you appeal from the planning commission to the county commission, I think, they allowed that appeal to go forward. And they basically said, well, we've got two tracks here. If your ordinance has that track, then that's how you do it. If your ordinance requires appeal, if the Board of Adjustment, if your ordinance requires the Board of Adjustment to make these decisions, well, the statute directs that those appeals have to be taken to the circuit court. That's now been cleaned up. So now it doesn't matter what body decides it, the appeal has to go to circuit court under a writ of cert.
On conditional use permits.
Once again, on conditional use permits. Thank you, Zach, because that's kind of where we've confined this to. My answer to you is this: it's jurisdictional. So you are going to lose. And that's one thing. If you are representing a potential petitioner, look at the law, look at the statutes, look at the chapter, what we've given you in this checklist. Do not get into an ordinance and say, well, the ordinance says I appeal it to the county commission, because if you do, and then you find out you get hit with a motion to dismiss it, it's going to be jurisdictional and you're going to lose. And then you're going to be answering questions from your clients about, well, why didn't we appeal this to the right place?
And as the attorneys that represent those boards, if the ordinance is wrong in that fashion, is it better to ignore your ordinance and follow state law?
Well, if your ordinance is inconsistent with state law, I think you have to follow state law. It's better to amend your ordinance and get it to match up, because otherwise you've got a whole bunch of, remember, the people you're representing are generally elected, and they do not like groups of people with pitchforks and torches showing up, at their meetings, screaming at them. And this is going to result in people showing up and screaming at them saying, well, you misled us. This ordinance, you tricked us. It's a good idea to go look at these things and clean them up, because there have been a lot of changes in the last 10 years, and in the last 5 even, that make some of these ordinances inconsistent with the law. And the law is going to control it.
There's
a question.
Yep,
yeah, is there a legal reason for the Board of Adjustment to go into executive session during a conditional use permit hearing? Well, the answer to that is maybe, but not because you want to avoid the pitchforks and the torches. So the short answer to that is probably not, unless it meets one of the requirements under the statute for the board to go into executive session. And anybody who represents these boards knows what they are. Is it to discuss litigation? Is it to discuss personnel matters? What's the third one? I mean, but they're limited. And what we see, and it's a great question, these boards will inevitably want to jump into executive session to avoid anybody finding out what they're doing. Now, technically speaking, they can't make a motion if they do that, if they do it in executive session, if they move to grant the permit, that's going to get rolled down the hill faster than you can, get it on paper. But as a matter of course, if you're representing these boards, do not let them go into executive session just because you get the sense they're trying to avoid having to have what they consider to be, a controversial discussion in front of the public. That's what they're elected to do. So there's probably not a good reason for them to do that. Now, is it going to result in the reversal of the permit? Probably not. Only because it's another one of those technicalities. I mean, if the board ultimately issues the permit and, issues findings that are consistent with the ordinance that allows them to issue the permit. But I will tell you, I'd prefer not to defend it. I mean, I'd prefer that they not be in executive session and having me have to explain to the court why, that's not, really that big of a deal. Somebody has gone to the trouble of laying out the reasons why they can go into executive session. So thank you for that. That's helpful.
So Tinsley put the statute you want to look at is 1-25-2 for executive sessions. And I wanted to make sure, Jack, that you saw before that came in, there was another question in the chat.
I just went up to look at it. Next question. So would you say for ordinance writers, you are better off just referring to the correct chapter, so when changes occur, you don't have to rewrite everything? I would tell you, for ordinance writers, don't put anything in there about appealing. Let the law control that. There's no reason to restate the law in your ordinance and say, if you want to appeal this, you must do so within 30 days by filing an appeal with the circuit court, 30 days of the filing of the decision. Just let the law control it. That way you don't end up with an ordinance that becomes out of date because the legislature tweaks the process and you don't catch it.
I have one more question. I'm sorry, I'm that person, but
go ahead.
So I know you've focused on conditional use permits, and I want to go back to the notice requirement and the waiving of notice if you showed up and you argued.
Yep.
Is that only as it applies to conditional use permits? Because we've had the opposite happen with zoning.
I think the law that we cite there is pretty general. I'll let Zach jump in.
Well, and I don't think that's necessarily a settled proposition, that it definitely acts as a waiver. I mean, I think, you're going to have issues if you just flat out don't notice a hearing. I think you're going to have issues upholding the decision. But I'm referring more to, if somebody claiming that your notice wasn't specific enough or something like that, that's not going to carry the day if they're showing up at the hearing and making their case.
And I think maybe that's the difference in the case we had, where there was notice, but maybe it wasn't sufficient, versus no notice at all. The case I'm thinking about may have been no notice at all. It's been a long time since I read it. So that helps. That answers.
Yeah, the notice issue we're talking about is really on a due process level. And so it really, what we're falling back on is the case law that's out there that basically says you can't complain about a technical notice issue for a hearing where you showed up and were fully heard. You've deemed to have waived that, technical irregularity, if there is one, in how something was noticed, if you in fact got there and were able to present your case.
Yeah, okay. For instance,
that helps.
In our world, like the Grant County Concerned Citizens case was one of the ones where this was raised, and they had transposed the number of adult hogs versus baby hogs. I mean, it would be a significant thing, but that wasn't enough for the court to say, well, this notice was wrong, we've got to throw out this result. It just simply wasn't enough.
Okay. Well, thank you. That's helpful for what I was wondering. It's 11:25. Does anybody else have any questions that have gone unanswered? Okay, wait. Oh, no, that was just a thank you in the comment. I also want to thank Jack and Zach and everybody in attendance for coming, and the South Dakota Public Assurance Alliance for sponsoring Jack's time. If anybody has any additional questions, you can contact the State Bar at info@sdbar.net. and they'll get them directed to the presenters. And once you leave today's webinar, you'll receive a survey on the presentation, and we'd appreciate any feedback. And I just want to finally say, on behalf of the State Bar of South Dakota, thank you for joining us, and I hope everybody enjoys their afternoon.
Bye, everybody. Thanks.